New Jersey recognizes each party's entitlement to share in the marital assets. It's called equitable distribution. It's defined by a variety of the statutes and factors that we would consider in how to allocate. New Jersey is not a 50-50 state, which means equitable distribution could be any variation of percentage. New Jersey defines marital property as that property that was acquired between the date of marriage and the date of complaint. Separate property is property that was acquired prior to the marriage or after the date of complaint. There are, however, some nuances to any specific questions you may have. To determine whether an asset is marital or separate, we would look to the date of marriage and date of complaint. We would look to how the property was acquired, how it was maintained during the marriage, any agreements you had in a prenup or any other agreements, and the general equity of division. If you have an asset that was acquired prior to the marriage and you kept it separate from the marriage, such as an investment account or a retirement account, that asset would likely be exempt from distribution. However, if you had an asset prior to the marriage that you ultimately commingled, then some or all of that asset may become subject to distribution. An example of a separate asset could be an inherited or a gifted asset. When we look at inherited or gifted, we look at the timing, what ultimately was done with the asset, whether it was maintained separate, whether it was commingled, and if it was commingled, was it enhanced or maintained by way of the marital partnership? When you have a separate asset, something that's in your name alone, and you convert it into a joint asset, you can do that by changing title or changing designation, or even if you keep it in your name alone, if you are funding it or contributing to it during the marriage, then you could inadvertently create a joint asset.